defendant, Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could unmute yourself and state your name for the record.
Very good. Okay, I got it.
You got it.
All right, you hear me?
Yep.
All right. So this is People versus Martin.
Yes, Your Honor. I have spoken with the complaining witness at the time. He would like to proceed with this case, and the people would ask to set it for a settlement conference before we go forward with trial to see if there's a resolution.
All right. And Mr. Darren?
I mean, Your Honor, I guess we're going to proceed that way. I was hoping, I'll renew my motion from the last time. Mr. Martin's been incarcerated. I think it's like 62, 63 days now. Court rule is pretty clear. If he's in over 28 days, he should be released on a personal bond. Mr. Martin's just been sitting in jail on this matter. I mean, I guess from practical, I would imagine the court's going to give him credit for time served, regardless of what the resolution is on this matter. Considering he's done over at this point, he's done over 2/3 of what his original sentence would be. We're not going to accept an offer on this, and I guess we'll just set it for a settlement conference then, if that's what sister counsel wants.
And Your Honor, it's I know this case has been going on for a while.
Personal bonds.
That's correct. The issue here is that him and the victim are brothers. They live at their family
First,
home.
I want to deal with the whole bond thing, because
Yes.
his bond is $2,500 personal.
So I think the issue with that is I was having a cover last week, but per the notes, if you recall, you ordered him not to return back to the property because there's a no contact order in place. 2 weeks ago, when Mr. Brother counsel appeared for the first time on this case, I believe I agree. And that's when the bond was changed, but Mr.
Who changed
Martin.
the bond?
Judge Kirsten. Yes.
So, Your Honor, Judge Kirsten changed his bond, and then after some further statements were made, he changed his ruling to leave Mr. Martin in jail.
And that's because Mr. Martin made comments about returning back to the location, the home where the victim lives. And to my knowledge, per my conversation with Mr. Martin, the victim today, he indicated he'll be leaving the hospital, returning to that house tomorrow.
Right. All right. So I'm going to.
I mean, I have no objection.
Mr. Martin, now listen, you understand? I wasn't here, but Judge Kirsten, your original bond was $2,500 personal. Then he set it at $2,000 cash because of the alleged violation that says it says need to set a hearing on violation ASAP. I don't know if there was I don't see anything whether there's an alleged violation of the bond condition. Is that right?
Not an alleged violation. He made comments.
He made a comment about it.
That he'll return back to the house.
This is why something. All right. So you understand you can't go to that house while you're on that. That's while the bond's in place. You understand that? Stay somewhere else. You understand that?
No, I do not understand, and I gotta stand up. First, I have nowhere else to go. Okay, so that's why I must return back there, and I object.
Welcome back to the channel, everyone. Today's video is a Sovereign Citizen Super Show. We've got not one, not two, but 4 of them, and the first 2 are absolute classics. We're starting with Eric Martin, the man who could have been a free man weeks ago, if only he didn't talk himself straight back into jail. That's right, this is the guy who turned his own mouth into a prison sentence. Now, if you've seen Eric before, you'll remember his legendary habit of arguing with every single person in the courtroom, including the walls. But today's update takes things to another level. We'll see his attorney fighting for his release, the judge trying to show mercy, and Eric being Eric. Then, we'll shift gears to one of my favorite repeat offenders, a sovereign citizen Karen, who thinks traffic laws don't apply to her, and her meltdown might be the most self-inflicted arrest you've
Objecting to the bond conditions before, objecting to them now.
Listen, your objection is duly noted. You have very, very highly competent counsel. So let's let your counsel speak on your behalf. And so he already did. He made a motion.
Well, I object to you speaking on behalf of that.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days and then you can just sit there anyway for it. Stop interrupting. Your Mr. Madera made a motion to set this for a personal bond. I'm going to set your bond at $2,500 personal. No contact with the victim or the victim's home location. And if you show up at that location and violate my bond, you can be held in contempt of court. Just want to make sure you understand that. I'm just telling you that right now. So I'm setting your bond at $2,500. I'm granting the defendant attorney's motion. And the bond's $2,500 personal. No contact with the victim. And no leaving the state of Michigan without the consent of the court.
I got something to say.
And you have a right to remain silent. And anything you say can be used against you. And you already have an attorney who's talking on your behalf. And I've already granted his motion and changed the bond to personal. So.
Hey, well, I have something to say in response to that.
See everybody at trial.
I have something to say in response.
We'll see everybody at trial.
Your Honor,
Mr. Darren, do you have anything else further?
Your Honor, are we going to set it for a settlement conference, or are we just going to set it straight for a trial?
Sure, I'll set it for a settlement conference, and then a week later it'll be the trial.
All right. Your Honor,
So let's pause for a second. Eric's attorney is doing everything right here, making a logical, well-argued motion for a personal recognizance bond. Essentially, that means Eric could walk out of jail today without paying a dime. But as you'll see, logic and Eric Martin don't mix. He's been in jail over 2 months for something that probably would have been resolved weeks ago. The judge is literally trying to help him, and his lawyer is teeing up an easy win. But Eric's biggest problem? He thinks he's smarter than everyone in the room. And that belief, that stubborn sovereign citizen ego, is about to cost him his freedom.
I understand the court's position. I mean, if Mr. Martin wishes to make a statement on his behalf, I can only advise him that I wouldn't. But if Mr. Martin wishes to make a statement and the court wishes to hear it, I don't have any. I mean, I'm not going to. I'm advising him not to say anything. But Mr. Martin, if the judge wants to hear it, if he's allowing it, then I will. I'll step aside and let you stay.
Mr. Martin, I've already granted your attorney's motion to set the bond at $2,500 personal. So if you have some other statement you want to make, I'm just going to reassure you again that you have the right to remain silent. Plus, your attorney's already said that, hey, you know what, it's probably a good idea to just do so. But go ahead.
Yes. Like I said, I'm going to exercise my First Amendment right to speak, and I have a lot to say. So I ask that you don't cut me off, or I'm done talking now. I object to the bond conditions and stuff. I can't be in my house. It violates my due process rights. I have nowhere else to go, and he's not the true victim. He's lying, saying he's a victim. But I told the cops when they arrested me that I was the victim. And so we have an equal protection clause violation.
All of that'll be the subject of the trial itself. So we'll hear everything you have to say about that.
And here it is, the moment where Eric could just nod his head, agree to the simplest bond condition ever. Don't go near the victim's house, and walk free. But no, Eric insists he must return there because he has nowhere else to go. Now, we've seen this pattern before. Sovereign citizens love to create impossible situations for themselves and then blame the system, but what he doesn't realize is that by refusing such a basic condition, he's giving the judge every reason to keep him locked up. Remember, the victim is his brother, and the court already ordered no contact. This is
one more time. Sit down. You are charged with 1 count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with 1 count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs.
I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis non de guerre.
I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested. You either go...
There it is, the courtroom equivalent of lighting yourself on fire while holding gasoline. Eric can't stop interrupting. Every word he says digs the hole deeper. The judge literally warns him. One more word, and I'll hold you in contempt. And what does Eric do? Keeps talking. Here's a tip for anyone watching. When your attorney says, "I got this," let them have it. Especially when your track record includes talking yourself into jail the last time. This judge is patient, impressively patient, but you can feel the irritation building. Watch closely. The moment Eric opens his mouth again, you can see that patience start to crumble.
Court is now on the record in City of Conneaut versus Amber McHenry, 24 TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning...
This is what makes Eric Martin a walking courtroom cautionary tale. The judge just granted what his attorney asked for, a $2,500 personal bond, no cash required. In other words, freedom. Done deal. Most defendants would be celebrating. But Eric can't help himself. He has something to say. Every sovereign citizen has that one fatal impulse, to speak when silence is golden. His lawyer even pleads with him not to. But Eric believes he's about to deliver some groundbreaking legal revelation. Spoiler, it's not. It's just another round of nonsense that risks undoing everything his lawyer achieved. Let's see how fast he...
herself in on the warrant. She's in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something. And
24 TRD 819.
819. Okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you.
And there it is, the classic sovereign citizen defense. I object to the bond conditions. I can't be in my house. It violates my rights. This is what happens when ideology meets reality. Eric's convinced he's the true victim, even though the person he allegedly harmed is literally his brother. That he judge, to his credit, stays calm and professional. He gives Eric every chance to stop talking, but Eric keeps going. At this point, you can practically hear his lawyer mentally packing up his briefcase. This is the kind of client attorneys tell horror stories.
Correct caption or case number on it is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I
while
did.
asking.
I exited the courtroom and asked a police officer, probation
Who has
officer.
the indemnity bond?
Uh,
Where is the bill of particulars?
The
Because
bond
I
is
did not
being,
receive it.
the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to
either.
the jail now.
Why am I being arrested?
And there we have it. Eric Martin, once again proving that freedom and common sense don't always go hand in hand. But don't go anywhere, because the next sovereign citizen might be even worse. T. Amber McHenry, a self-proclaimed authorized agent of a decedent estate, who thinks her expired plates and missing driver's license are somehow protected by the Constitution. What makes this case wild is how small the stakes are. Just $300 in fines. No jail time.